Well,
Okay, this is good.
I was just gonna cook a night, is that easier?
Yeah, maybe like a night before you or something.
No,
We're
wherever you-
Sam's pretty good now, so, yeah. Like your lunch counter, your truck might be better, it's already.
you know what, Beverly is great.
What's a good day for you? 'Cause we're kind of flexible.
I'm so sorry I'm making a mess.
Yeah, you're right.
I'm always afraid we'll get mice, because I know this place is full of them.
It is. Just put everything on the ground.
Never seen one running around.
Yeah, oh, and I need to send in the RFP. It's on my dining table.
Actually, yeah.
Oh, really?
And I got
You did not. You didn't.
I went to the Woogie Wagon up in, Topsfield, Big Shop. So,
They have food free one?
yes.
That is crazy.
But it's a good time.
You guys come in, because you've got to come from Boston.
Yeah, it's like, anything like six and stuff.
No, it's really up to you. I'm thinking, are you both on the train?
Yeah, he goes down the street to go.
So what will you do, get off at Beverly instead? Then how are you gonna get home?
We'll go to Beverly Morning. We'll go to Beverly Morning.
Oh, okay. I'm like an old lady, I'm like, now how are you gonna get home? Yeah,
What's a good spot?
I'm trying to think what's close to the train station.
So it's, we're gonna have to take the car right on.
Oh, yeah, but will you guys be hungry? There's so many places.
There are.
that I can't, um, Let me think about it.
Yeah, just text me. We'll put it in the 6:30.
I'm doing that.
Everyone likes it.
Or not.
So you probably like this.
Yeah, but I got covered.
No, I know, but it was hilarious. I was like, where is he gone?
Yep.
Those Wednesdays. What? It's gonna be one of those Wednesdays. I'll be here. Did I hear you come downstairs? Alright. Yes.
just to fill out the drama?
What?
You think she had a tooth pulled just to fill out the drama?
Marilyn went upstairs because she didn't want to start without other people, but now everybody's people.
Maybe she went upstairs.
The fourth floor. That's not where the chairs are.
No.
Where are the chairs again? I know you know everything.
I just asked for them and they appear.
Oh, you just ask and they appear?
Yes.
I thought they were in a closet.
They are someplace. She's on the fourth floor. She's hanging around the State House News Service.
You're probably right.
I'm pretty sure I am.
How many do you need?
I'd like to put a few more in here if we have some space. There, we could do them along there, and we could do another one there. I feel like we got more chairs.
Oh, I can put an inner circle inside. No?
You put them in front of the doors,
Yeah.
just like the fire marshal likes.
Yeah, he does like that, doesn't he?
Okay. Let's see what we got. You don't know if she's gonna go with that chair or not.
Oh, that's why we have it there.
Well, it doesn't look right. So I know correctly what we have.
That there'll be some reaction.
Yes.
Okay.
Okay, yeah, just like 5 to 10, whatever you have available. Okay, thank you.
Nobody's aesthetically that thrown off by that. Thank you so much.
There probably is 40 over there, so. Thanks, Reese. Thank you.
Oh, good.
She said she knew it.
Oh, perfect. I'll follow up. Awesome. Good stuff. You can, if you want. Yeah, I just feel like she can. You want a chair? No, I don't. We're getting more chairs, but.
Who's there? You should just have this.
Hello. We'll have a chair for her.
I'll snatch this one. It's a good thing from here.
It's an empty chair next to Terry.
Yeah, that makes it too hard to get out.
True, true. You'll feel a little trapped in there. Yeah.
Here's there. Here's here. Here's here. bringing more chairs in, but anywhere you see a chair, you're welcome.
Very nice to be here.
How are you? Great, how's it going?
Thank you so much. That's exactly what I wanted to do. Thank you so much.
There's all these chairs.
Nice to see you.
Morning. I waited until the councils came. I didn't want to be alone in the chamber, so I thank you for your indulgence. I welcome you all. I'm now Peter Deakin, and I will be presiding today. And I welcome you. And I would just want to say that if anyone wants to speak, including the nominee, you'd be sworn in. So, first of all, I'm going to introduce the councilors who are here. Council Julio, Council Duff, Council Hiller. And
Kennedy's was called trial this morning. So he's-
yeah, I know, we have lawyers to go to trial. Okay, so anyway, first of all, I'm going to call on your witnesses in the order that you have given them to me, okay? And so we have, first, we have the Honorable Holly Broadbent, Associate Justice of the Lawrence District Court. Morning. You can sit right there beside me.
All right, members of the Governor's Council, good morning. For those of you I haven't met, my name is Holly Broadbent, and I'm the judge in the Lawrence District Court. But my relationship with David began in the Suffolk District Attorney's Office when, in his role as the Chief of the Family Protection and Sexual Assault Unit, he began supervising my work as a Superior Court prosecutor. I am so happy to speak as a witness for David today, as I consider him both my mentor and my friend. I credit David personally with my development as a prosecutor and as a supervisor. For over 12 years, I worked with David on an almost daily basis. It is no secret that David is a highly effective and well-prepared trial lawyer, and I know members of this council have had a chance to review in his application the types of cases he has tried as a prosecutor. I'm also confident that everyone in this room has read about some of the high-profile cases that David has handled as well. But regardless of publicity, David approached every single case with the same principles in mind: to seek justice for victims, many of whom were among the most fragile or vulnerable our system sees, to treat defendants, even those charged with the most heinous and unthinkable crimes, with the utmost fairness and compassion, and to represent the Commonwealth with the highest degree of ethics. David worked tirelessly to make thoughtful and careful sentencing recommendations that reflected a thorough consideration of not only the impact of the crime on the victim and the safety of the community, but also of the offender in any extenuating circumstances. Intelligence and trial skills aside, David has an excellent reputation in our community because of how he approaches the role of prosecutor and supervisor, and also because of the type of person that he is. David is above all else something kind of rare for a trial lawyer. He is humble. While other lawyers sometimes celebrated a victory in court with an adult beverage after work, David always chose to mark the end of a long trial with a very simple tradition, buying pastries at the same bakery to take home to his family. As a supervisor, David was supportive and understanding of his staff, but he also had the ability to offer them straightforward, constructive criticism, and they respected David for that. You should also know, members of the council, that David also supervised in the DA's office, the largest bureau in the Suffolk DA's office, that was comprised almost exclusively of women. I credit David and I thank him for encouraging the promotion and advancement of women in that office to supervisory positions and for supporting extended maternity leaves and equal pay as well. He was an advocate for all of us. I have been very fortunate to know David as a mentor and friend throughout my career, and I know many who would say the same thing about him, and many of the women are sitting here in this room supporting him. David is a fundamentally decent and kind person. I have not worked with David for almost 5 years, but there are still many days where I miss his wisdom and his advice. There simply isn't a person that I could recommend more to this council. I have no doubt that if he is confirmed next week, he will make a lasting contribution to our communities across the Commonwealth with the same sense of integrity and fairness that he has always shown. Thank you for your time.
Thank you. Does anyone have any questions for the council? Well, thank you very much.
Thank you.
Appreciate your testimony. Our next witness is Ashley White, Assistant Clerk Magistrate, Gloucester Municipal Court, Dorchester Division.
Good morning, everyone. Good morning again, ladies and gentlemen. My name is Ashley White, and I'm an Assistant Clerk Magistrate in the Dorchester Division of the Boston Municipal Court. And it is my honor to be here today before this distinguished body. It is also one of the greatest honors of my career to speak on behalf of Attorney David Deakin, whom I consider to be the ideal candidate for the Superior Court because of his willingness and ability to make fair and well-balanced decisions, his experience, his intelligence, and above all, his ethics and his character. I first met Attorney David Deakin when I was an Assistant District Attorney in the Suffolk County District Attorney's Office. By then, he was already Chief of the Family Protection and Sexual Assault Bureau, overseeing all child abuse, domestic violence, and sexual assault indictments. And make no mistake about it, those are the toughest cases to handle in criminal law. But I really got to know Mr. Deakin when I became a criminal defense lawyer, a bar advocate, who represented clients in Suffolk Superior Court. We became acquainted through a case called Commonwealth versus Daniela Alvarez Jimenez. This case was not only one of the most intense cases that I ever handled, and I assume he would say the same thing. It was one of the worst allegations of child abuse you will ever see in the court system. Ms. Alvarez Jimenez had a son. To summarize, over a 6-month period, her son suffered the following injuries: fractures of both humerus bones, posterior fractures of the 8th and 9th ribs, fractures of the sternum, fractures of both tibias, and a fractured femur. To put it in more common, non-medical terms, he suffered 2 broken arms, 2 broken ribs, a broken chest bone, 2 broken shins, and a fractured thigh bone, which of course is the biggest bone in any person's body. Horrendous injuries for an adult, but unconscionable injuries for a child. At the time those injuries were discovered, he had just turned 1 year old, which means these injuries were inflicted when he was just an infant. So when we say they were inflicted over a 6-month period, he had essentially been abused for his entire life. Adding on to that is when police questioned the defendant about the incident for a variety of reasons. She lied to the police about who had been home with her son at the time the femur was broken. Needless to say, the stakes at trial were high, and at every step of the way, Attorney Deakin showed he was a master of the law and had the highest ethical standards. and let me explain how. First, let me start with how he annoyed me. Normally, as you are in the pretrial stages, there is a typical song and dance between defense lawyers and prosecutors. Defense lawyers demand discovery and chase prosecutors to get it. When we don't, we complain to a judge and sometimes look for sanctions if it's not provided. In any event, it's usually the defense lawyer having to chase down the DA for more information. In this situation, it was the reverse. Every week for months, Attorney Deakin was emailing and calling me, telling me to pick up additional information that he had about the case. Medical records, taped interviews, DCF reports, additional statements, photographs. It seemed like every other day, there was a new package in my office with his name on the return address. I remember complaining to my colleagues, can this guy stop? He's not giving me anything to complain about. When the judge asks me how the case is going, I'll have to report there are no issues and everyone in the room will think I'm a pushover. Why does this matter? Because even with the most horrific allegations, he wanted to make sure the process was fair and that my client and I quickly had access to the same information that he had. An understanding that is critical for anyone who wishes to ascend to the bench. But that's who Attorney Deakin is, someone who saw his obligations as sacred, not negotiable. Along those same lines, the defendant had been indicted on 3 separate charges. I want to talk about 2 of those. One was an assault and battery on the child, meaning that she directly inflicted the injuries. The other was recklessly allowing another person to inflict the injuries. Because it was unclear initially if she had done it, boyfriend she had been seeing had done it, or her ex-husband had inflicted the injuries. As we approached trial, I was ready to raise hell about the fact that there was no evidence that my client had directly inflicted the injuries. And at best, all the evidence pointed to someone else inflicting them. Before I could say anything, Attorney Deakin approached me and said, we're dismissing the assault and battery count because we don't have sufficient evidence of that. We're only going to proceed on the counts that we have sufficient evidence on. Again, stealing a big chunk of my thunder. He stuck to what he could prove and where the evidence pointed after the investigation was completed. Some people kill you with kindness. Dave Deakin killed you with logic and reason. Why does this matter? Because it's important for judges to hold the government to their burden of proof to each element of each case. We know that he will do this because it is a standard that he held himself to. But what may have been the most impressive thing is how he handled himself at trial and what he did after the jury returned a verdict of guilty. You've heard the allegations. A young child had a broken body, essentially from head to toe. I want to tell you a little bit more about the circumstances as we proceeded with this case, and I'll start with the jury selection. As a DA and a criminal defense lawyer, I had tried countless amounts of drug cases, firearms, domestic violence, shootings, and later on homicides. In all those cases, I had never experienced a jury selection anything like this case. The judge asked the jury pool if, because of the allegations, would it make it impossible for you to be fair and impartial. In every case I tried, maybe 2 to 4 jurors maximum answered that question, yes. In this case, 13 separate potential jurors raised their hands and said, based on the allegations alone, they could not be fair and impartial in this case. 3 separate jurors admitted that they would hold it against her if she did not testify, which at first didn't necessarily seem abnormal. But when questioned by the judge, their response was anything but normal. When this juror was asked, why do you feel that way? She said, I think she'd be lying. I think she's pretty disgusting, actually. Anyone who hits a child is disgusting. If she's in court right now, then she did it. Another juror stated, I don't feel I can be fair and impartial. Even just hearing the charges was making me sick. At least 5 other jurors asked to be excused because of prior professional or personal experiences with child abuse. This is what we were up against before we heard from one single witness. And we were also up against this reality. The worse the allegations, the more likely people are to prejudge and not even listen to the other side. But Attorney Deakin did the opposite. In this case, there was actually more to the story. Very briefly, the defendant had not inflicted the injuries on her son, and in fact, it was a boyfriend whom she trusted. This man had deceived her, hid things from her, and misled her. She was an unsophisticated person who had immigrated from Colombia at a very young age. And also, although she was 22 years old, she had the emotional and psychological maturity of someone 14 or 15. She did not speak any English when she came, and she struggled to support herself economically and physically. Most importantly, she had taken her son to the hospital 5 separate times, 2 separate hospitals. Each time, on those 5 separate occasions, they told her her son was fine. It wasn't until he had a broken femur that the doctors at Mass General see that he had several other healing fractures. To put it simply, 2 separate hospitals completely missed the injuries and told the child's parents that everything was okay. It was also clear that our institutions had failed this young lady as well. In fact, so much information about Ms. Alvarez Jimenez's circumstances came out of trial that a juror who convicted her wrote a letter to the court asking the court for leniency. But the fact was, because of Attorney Deakin's brilliant advocacy, they found her guilty. And the truth was, I expected him to ask for a lengthy state prison sentence. That's how the process normally goes. The facts were serious, and I made him go through a 6-day trial with interpreters, complex medical evidence, and witnesses changing stories while on the stand. I fully expected that he would ask for a lengthy state prison sentence because he had the power to do so. But instead, Attorney Deakin came to me and said, after hearing about all the circumstances of the case, some of which he didn't know until trial, he had changed his mind. That after hearing all the evidence and considering all the factors, he was recommending a different sentence than what he initially thought, that focused on improving the lives of all the parties involved in this case. The amazing part is not the specifics of the sentence that he recommended. It's the fact that he was willing to consider all the circumstances even after he had won. In a case where so many people prejudged the case because of their emotions, Attorney Deakin, the one who had the most incentive to go after her as hard as he possibly could, used skill and logic instead. Again, Attorney Deakin killed you with reason. He didn't recommend a sentence because he could. Instead, he tried to do what was right. He saw his obligations as sacred, not negotiable. And this is what will make him an ideal judge. It is easy in an intense case such as we had for things to go south because it's contentious, and that's the way sometimes the process has to be. After seeing each other straight for 6 days, all attorneys can't stand the sight of each other. However, everyone left this case, including me, with more admiration, more respect, and more affection for such a phenomenal lawyer and person. Oh, and by the way, in case you didn't know, he's a Harvard guy and he's smarter than everyone. He's methodical, he's precise, he's balanced, intelligent, honest, and a gentleman. Simply put, he was the best lawyer I ever went up against. And and even a better person. And these same qualities will make him a phenomenal judge. Thank you for indulging me today.
First of all, I want to disclose, I had a huge roll-up report yesterday. Whatever drugs they gave me, they haven't worn off yet. I did not read the letter from the governor, and I did not swear you in and everyone, so I'm going to do it a little late.
Yes.
But let me read the letter first. Sure. And first I want to introduce Counselor Atty.
Good morning. My daughter's a Harvard girl, too. She's a junior.
The letter from the governor. Dear councilors, I am pleased to nominate David A. Deakin to the position of Associate Justice of the Superior Court. I submit this nomination with the advice and consent of the Executive Council pursuant to Chapter 2 of the And now if I could retroactive, you two have already spoken, and then anyone who wants to speak, you swear to tell the truth? You swear to tell the truth, the whole truth, and nothing but the truth, so help you God. Thank you. First of all, I'm going to open it up to the council, but I, as the facilitator, I speak last, but I have to say, I have been here 20 years, and I have never heard a more outstanding testimony. Really, really, you are a credit, and to this nominee to be here to support him. So having said that, I'll open it up to the council. Councilor, I know.
Thank you very much. What was your role in that trial? You the assistant DA?
I was a defense lawyer.
You were the defense.
I'm sorry, not explaining.
Okay, no, it's my fault.
I was a defense lawyer, and Attorney Deakin was the assistant district attorney prosecuting the case.
You know, you did a phenomenal job, but I got a but. You know, you said something like, usually, I don't do any criminal law, I just do personal. But you said oftentimes defense attorneys are chasing the prosecutor for discovery materials. This guy was different. Am I right?
Yes, that's correct.
To me, that's troubling that shouldn't they all be like him? Shouldn't all prosecutors be like him? Why should defense attorneys be chasing everybody for discovery?
Can I respond?
Yeah, I'm asking a question.
Sure. So I have two responses to that. My number one response is certainly all prosecutors should strive to be like that. All prosecutors should be like that. There are some prosecutors who might fall below that standard. However, I would say as a former assistant district attorney, you have certain realities about being extraordinarily busy depending on your assignment. You're very busy urban courts. You're in very busy superior court at times. So there are times when people can overlook things. There are times when the process can move a little bit slowly. So defense lawyers have to do their best to hold prosecutors to that standard to try and get as much discovery as possible. People have different skill sets at different times. It doesn't mean everyone's hiding it from you. Sometimes someone might be a little bit slower in getting those things to you in the process, but he certainly did not have that problem in our case.
Yeah, well, when you were talking, to be honest with you, I got the impression that he was exceptional. But now, in that this isn't the norm, that's the strong impression that I took. Hold on. Hold on. I feel like you're trying to back off a little.
No.
Hold on. That, you know, it may be one or two and they're busy. You know, people's lives are at stake. If they're too busy, get someone else. How many, you used to work for, were you an assistant DA in Conley?
I was.
There's a lot of prosecutors there. How many?
I don't know how many.
We got a lot. We have about 200. How many people, you know, when you're a defense attorney, how many in your law office at the time?
I was in solo practice.
Solo practice.
Yes.
So you're here by yourself. And I like Dan Conley a lot. I did a lot of work for him. I supported him for May. He's a friend of mine. You got 200 assistant DAs. They're busy. They got other things. People's lives are at stake. Look at charges like this. That's now I think you're telling me, well, sometimes they're too busy, so they can't respond to the discovery the way they should at the detriment of the defendant. And generally, the defendant is a lot of people like you, just a one-man shop. You think that's fair?
Well, so no, I don't think that's fair. And anyone who does not comply with the discovery obligations, is my experience, also faces a consequence in our courts.
I got all
But
that.
if I could just add one more thing, I would also say that when I was speaking about Attorney Deakin, what was exceptional was not that he provided discovery. That's not exceptional in the litigation process. What was exceptional about him was the speed in which he did it. There are time limits that we have in court where prosecutors can provide discovery. The overwhelming majority of prosecutors comply with those time limits, although it's on us to make sure we're calling and asking for things. He was a person that did it with a speed a speed that was unique. And I think that deserves to be called out for being exceptional.
Okay, so we got it a little quicker then. That's a lot different than the impression you get.
Yeah.
So he was a little quick to get the discovery, but, which is different, what at least I took, because all the DAs, they're all, most of them, really, they all get. I thought that was a little different. Then you said this, you know, you have to report to the judge, and you said, no issue. You go, that's because of Attorney Deakin, very unusual. Why is it unusual? It goes down.
Well, it's unusual because in cases, especially when you get to the Superior Court level, you have cases that are voluminous. You have, like in this case, thousands of pages of medical records. You have 1 million taped interviews. You have probably 15 different reports written by the police. And then you make requests for additional discovery that the prosecutor might not have thought of yet. You make your request saying, hey, I saw this, can you please get me this? With so large of an investigation, to be able to move that quickly, I think is unique and a credit to that individual person. Because it is complicated for a prosecutor to put those cases together, to get everything over to the defense lawyer, in terms of automatic discovery, and in addition, things that they might ask for that are on top of the automatic discovery. And that's why I say that that's a little bit unique, because I didn't have to come in and say, now that he's provided me discovery, I also see that I need this. And then the prosecutor will say, okay, I'll go and get you that. He had covered all those bases even before I could think of what additional information that I needed. And that was a testament not only to his carefulness, but his experience, I would say.
I get it. I thought initially, to be totally honest with you, this guy was like a super guy. I mean, he does this, he does that, but I'm getting the impression he's a little quicker than other people.
No, he's good at it.
And they have voluminous medical records,
Yes.
correct?
Mhm.
So many investigations. You're a one-man show. There's 200 people in the DA's office. Give me a break. Give me a break.
They're not all assisting him with that.
I understand, but guess what? They have help.
Yeah.
They got it. I know the system. I know it. Okay? They got interns. They got enough. They got a lot more help than you. You agree?
I agree with that, yes.
Any doubt in your mind?
No.
No doubt. No doubt in my mind. I mean, I got the impression that he was, and I loved your testimony, but I'm coming back a little. I was under the impression, wow, this guy is great. He's amazing. He does this, and it's not normal for assistant DAs to do this. They don't do it as quick as him. He does. Wow, he's great. But after questioning, he may be a little bit better. He's not like, because most of the DAs give you the discovery, there's no issue. Most of them do this. So, it was a little thing you said about the sentencing. You said it. Most district attorneys, most assistant DAs would have recommended a lengthy prison term, correct? You said it, I wrote it down. So, to me, that means, okay, that's good so far, I like it. But it's great for him, and I really like the story, but what about these other assistant DAs on this case and that case? Wow, maybe they're doing something a lot different than him. They're probably recommending, to use your word, lengthy prison time. And he did. So my question is, did he get it right? Or all those other DAs who don't, are they getting it wrong? Because they can't both be right.
Sure. So in our case, Attorney Deakin, I believe, got it right. I'm obviously a little bit biased. I was a defense lawyer in the case, but I believe he got it right. There are several circumstances over the course of my career where I believe some prosecutors have gotten that part of it wrong. That simply because you won a trial doesn't mean you should ask for the penalty to be increased. It runs the gamut. I can't say what's the average. I will say that there have been times in my career where I've disagreed with the prosecutor's recommendation and thought that they could have given a little bit more thought to some of the factors.
Well, as a defense attorney, I used to do criminal cases way back when. I did court-appointed work when I got out of law school. So I've handled hundreds of criminal cases in many years. Oftentimes, you disagree with the assistant DA, right?
Yes.
So, but in this case, you totally agree with his recommendation.
Yes, which was slightly different than mine, but I appreciate it.
Totally agree. So again, which I like what he got, but I'm more troubled about your experience with other assistant DAs. He seems like, according to your testimony, haven't asked him any questions. He's phenomenal.
Yes.
Why ain't the rest of these DAs? I mean, people's lives are at stake. People go to jail. I mean, what did he recommend in that case?
I believe he recommended a split sentence, 2.5 years with 6 months to serve, the balance suspended for 2 years afterwards.
That's a pretty, I mean, I don't really know the facts of the way.
Yes.
So that to me seems, again, more than reasonable.
Yes.
Okay, and from the facts, the way you lay them out, and I understand the board from that, I think at least in my very limited, it's been several years, I applaud him for that.
Yes.
But I think most assistant DAs, would you agree, would have more likely than not recommended a more lengthy sentence.